This is episode 479 of the Rio Grande Foundation's Tipping Point, New Mexico. I'm Paul Gessing, president of the Rio Grande Foundation, New Mexico's free market think tank. You can find out more about the foundation at riograndefoundation.org. I am very pleased to be joined by a return guest, that is Daniel Suhr. He is an attorney at the Liberty Justice Center, and I know you are you have a more formal title than just attorney, but to me, you're just our lawyer on multiple cases now. But Daniel, thanks for coming back on.
Thanks for having me back on, Paul.
And what is your formal title?
I am the managing attorney at the
Managing
Liberty
attorney.
Justice Center. Oh yeah, we've got minions now, Paul. We got
all right. Well,
staff attorneys who need to be managed. So I'm managing attorney.
You're a busy guy. There's no question about it. And I appreciate your taking time out of your day. You're not just busy with cases here in New Mexico that you're working on with the Rio Grande Foundation, but that's certainly something that I'm sure we're keeping you on your toes, so to speak. But before we get into all these New Mexico cases, let's talk a little bit about Liberty Justice Center. And, certainly a lot of folks who follow litigation at the Supreme Court level are familiar with one of your cases, but just talk about your broad philosophy and some of the cases people might be familiar with.
Yeah, sure. So Liberty Justice Center is a nationwide nonprofit, nonpartisan law firm. We represent all of our clients for free, and our mission is to take on the biggest fights on behalf of liberty. And so that means we get to sue all the right bad guys. We get to sue the teachers unions. We get to sue blue state governors doing bad things. It's really a joy every day, Paul, to represent great clients like you, and take on these big fights. So I'll just mention maybe two or three kind of recent cases that would be special interest for your audience. One is the National Horsemen's Association. So you may or may not know this, but last year, Congress mandated a federal takeover of the horse racing industry. Horse racing, unfortunately, has been fighting some of the same doping concerns that we've seen in other sports. And so Congress responded by passing the Horse Racing Integrity and Safety Act as part of a midnight, omnibus kind of package thing.
Who could be against integrity and safety?
Safety, I know. It's for the horses. It's for the horses. It's like saying it's for the children.
Right.
And in this instance, rather than creating like a federal agency of horse racing, what the Congress did is they gave federal government power to a nonprofit private organization to regulate horse racing nationwide. And so this private nonprofit has the power to issue subpoenas, the power to issue fees and fines, the power to write the rules for horse racing, really just across the board regulatory authority for the horse racing industry, displacing what had been the 38 state racing commissions that had regulated it previously. So just in December, we had a huge victory at the U.S. Court of Appeals for the Fifth Circuit, which covers Texas, Louisiana, Mississippi, which for only the second time in a century said that the Congress had gone too far in giving governmental power to a private non-governmental actor, right? Like ultimately our Constitution expects that government exercises governmental power because we elect the government, right? We vote on the government, and the government's subject to accountability and transparency. You can FOIA the government. You can't FOIA a private nonprofit organization. You don't have a Senate confirmation vote for the director of a nonprofit organization. And so the Fifth Circuit said that just gone too far in granting that kind of power. And my hope, obviously, is that will set a landmark precedent that we'll use in other cases as we see the administrative state grow and grow and grow. Not only have they been giving more and more power to bureaucrats, but they've been giving more and more government power to these nonprofit entities. And, we want to kind of pull that back as part of the overall fight against the administrative state. So that's at least one fun case we're working on.
All right. Well, that's definitely an interesting one. We have some horse racing here in New Mexico, including horses that have gone on to win some of the big races. I think the Kentucky Derby in a major upset. But don't ask me to get any further in depth on horse racing. On a different issue that certainly Liberty Justice Center has made its bones on at the U.S. Supreme Court. You brought, on behalf of Mark Janus, a government employee from Illinois, a case to the Supreme Court. What's it been, almost 5 years now since you won right to work for government employees across the entire country, right?
Yeah, it's a huge victory. The case is called Janus versus AFSCME. Mark's now a colleague of mine, actually. He works here at the Liberty Justice Center, and he is the most normal guy, right? He worked in Illinois state government doing child support enforcement. So basically an accountant on deadbeat dads. And as part of that job, he was required to pay hundreds of dollars a year to a government union, which would then turn around and spend that money on things Mark didn't believe in. Mark's also a conservative guy, and the obviously government union was using his money to support a whole bunch of liberal agendas, and that just didn't sit with Mark. That's not what he wanted. And so Mark did that most American of things. He sued somebody. And in this instance, his lawsuit went all the way to the U.S. Supreme Court, as you say, about 4.5 years ago, that the Supreme Court, in a landmark decision, said, no, the government can't force employees of the government to pay money to a union as a condition of employment. So since that time, in those subsequent years, we've had a lot of litigation around what that means going forward. Our hope at Liberty Justice is to establish the right of public employees, not just to have this right to refuse, but to know about it. So often when you get hired into a government job, the union shows up at new employee orientation and hands out the union membership form, and your HR director is there, and they're like, hey, join the union. And nobody ever tells you, hey, you have a right not to join the union. It's all just sort of baked into the system. It's assumed, especially if you're not in a right to work state, and if you're a state like New Mexico, where there's not that culture of right to work. It ends up a lot of people, according to polling that we've done, actually don't know about their constitutional right not to join a union. And so our goal now in this kind of post-Janus phase is to establish that before a union can ask you to join, especially in a government workplace, they have to tell you you have a right not to join, so people don't miss out on exercising their First Amendment rights. So that's the next fight we're fighting. We actually have a case right now in the Seventh Circuit trying to push that argument, and we're hoping to go back to the Supreme Court to eventually make sure this right is not just established, but that it's meaningful for all these public employees.
Got it. Well, that was a huge case, and it continues to reverberate and give government employees the freedom to choose unionization or not. And kudos on that. That's a huge decision. And I've met Mark a number of times. He came out to New Mexico during the early part of the legislative session a few years ago. And he is a very just humble, average guy, and the kind of person you probably want working for government if you want government doing all the things that it's doing. But we could digress into a lot of unfolding of that particular argument. So let's get into some of the cases that we've got going on right here with you and your firm. Specifically, the more recent one is City of Albuquerque. Council decided to give $250,000 to a private organization. We have an anti-donation clause in New Mexico. It's been beaten, it's bruised, it's bloodied, but the anti-donation clause is still the law of the land. Let's talk about that particular case and what's going on with it.
Yeah, sure. So the fundamental principle is pretty simple. Politicians don't get to use your taxpayer dollars like their personal piggy bank to support agendas and causes that they believe in, but that aren't reflective of taxpayers, that don't deliver value for taxpayers. So that's a pretty simple proposition. It's common sense. I think people would agree politicians shouldn't use your money like for their charitable donations. And that principle is embodied in the New Mexico Constitution in what you rightly refer to as the anti-donation clause. The anti-donation clause has been there for a century. It's been there, I think, since the beginning of the New Mexico Constitution, because there was this concern, especially at the time, New Mexico was founded, the West was developed, that there were these railroads and other, monopoly industries and monopoly organizations coming in and getting these sweetheart deals from the government. And the founders of New Mexico, rightly, wanted to ensure good government. And so they put in place this clause that said the government can't use taxpayer funds to make a donation, an anti-donation clause. You might also call it like an anti-earmark clause to a private, nonprofit, or for-profit organization without getting something for it in return. The taxpayers have to get some service or value in return. So that principle has been around for a century. And as you say, Paul, it's been observed sometimes. It's been less rigorously observed other times, sort of a modern day economic development strategy and tax credits for companies coming with business have seen that principle change a little bit, but the core is still there. And that's the basis for our lawsuit in Guessing versus Yara. One of my favorite names on any of our lawsuits, Paul.
Yes, we're not guessing. We actually know and strongly believe, based on the law, that this is a good case. But wow, thank you for. I guess that's the way it goes. Yeah, because technically, while Rio Grande Foundation is something I'm identified with by many people who don't know me personally, it's actually myself, along with a abortion, what do they call it? Education, crisis pregnancy, called CareNet. So, but the name on the case is mine. That's wild. Good stuff. So this is just filed with state court. How do you see, hopefully these courts are past their COVID slowness, because that was an issue for sure. But where is this thing going?
Yeah, so as you mentioned, in May of last year, the Albuquerque City Council took a series of votes throughout kind of the summer in response to the Supreme Court's Dobbs decision that they decided, let's just take $250,000 and we're going to give it to Planned Parenthood, this private nonprofit group, as a donation. We're just going to give them funds. It's called a council-directed sponsorship. If you're listening to the podcast rather than watching the Facebook Live, you can't see my air quotes around that. But it's a council-directed sponsorship of $250,000 to Planned Parenthood, basically as a political statement. It was a statement by the council that they didn't like the Supreme Court's Dobbs decision. And that's just not how they get to use our money. As taxpayers, you, Paul, as a taxpayer, you're paying property taxes, you're paying sales taxes in Albuquerque. That's supposed to go for police and fire, right? It's supposed to go for schools. It's not supposed to be a place for the city council to take your money and make a political statement about what the U.S. Supreme Court's doing. So we filed our lawsuit a few weeks ago on behalf of UPaul and CareNet, as you mentioned, the Crisis Pregnancy Center. And really the reason we represent CareNet is because they never got a chance at this money, right? The council afterwards, after they knew they were going to get sued, said, well, we just want to support women who are pregnant with health services. Well, that's fine. But then CareNet, as an organization that provides services to pregnant women, they should have had a fair shot at applying for those funds if it was truly going to be an open competition to provide a service. But it's not. And we know it's not, because their whole point all along was about making a political statement. And that's exactly what the anti-donation clause is there to prevent. So this case has never been about abortion politics. This isn't about Planned Parenthood. This is really about protecting that principle in the state constitution that says politicians don't get to use taxpayer money to support nonprofit or charitable causes that they believe in, that they have to take care of taxpayers first.
Yeah, and just as a little bit of additional history, of course, that was in New Mexico's constitution, which was enacted in 1912 when New Mexico became a state. The railroads, as you mentioned, were the prime target of the anti-donation clause because the state of New Mexico and many other Western states were, giving sweetheart deals to these private corporations to get them to locate their tracks and various services in the state. It's a classic case of this economic development. Now the legislature, and I believe this was done through the constitutional process, which involves both the legislature and a vote of the people. And I don't have my dates exactly right. I think it might have been during the 70s where they opened up the anti-donation clause for economic development. So they basically went directly contra to the intent, wise as it was, of the anti-donation clause. So now that we, the people of New Mexico, can subsidize, private corporations for economic development, but it's pretty hard to argue, I believe, that this donation to Planned Parenthood is economic development in any way, shape, or form. It seems to still violate where the anti-donation clause was intended, in terms of stopping government officials from just handing our tax dollars over.
Yeah, that's right. You're exactly right about the history, Paul. And one of the things that's so encouraging to me as the lawyer on this case is if you go through the New Mexico Supreme Court's cases interpreting the anti-donation clause, and that matter, on a bipartisan basis, the Attorney General office in New Mexico over the course of the past century, like you said, this has been around a long time. So there's a good chunk of law interpreting this provision, and the principle has always been the same. It's exactly the one you just enunciated. Politicians can't just give taxpayer funds away. They have to have, you can contract, you can make a deal with a nonprofit organization to provide a specific set of services, but you can't just give the money away. And that's what they did here. They wanted to make a political statement, and so they just tried to give this money to Planned Parenthood to make a political statement. That's obviously not providing a service to the people of Albuquerque, and so that's why it violates the clause. And there is a large body of law that's developed over the course of the past century that I think is going to lay out pretty clearly why that's illegal.
Yeah. So we'll see. This is in New Mexico District Court currently, right? And how, based on your experience, New Mexico and elsewhere, when do you think we'll be getting a hearing on that?
Yeah, it's a great question. So we actually I just got the first email today from opposing counsel saying that they formally got served with a lawsuit. This is always the fun part at the beginning of the lawsuit, right? When you get to serve the other side. But that
do they really have to chase them down? Like, obviously, this is the city council or their minions or representatives. How does that work? Because thankfully, I've never been served with a lawsuit in my life, so never had to, like,
keep it that way.
You see these fictional accounts and people are like, hiding and running away. I can't imagine that's the way it works with the city of Albuquerque.
No, it's not. Thankfully, frankly, we use professional process servers. Like, there are people who do this for a living, and 99% of the time it's just a very simple visit to somebody's office, and you just have to sign a form. I used to work for Governor Walker in Wisconsin, and that was one of my jobs, was when somebody showed up in the front office, I had to go up as the lawyer and sign on behalf of the governor to accept the service of process. And so it's a pretty simple, straightforward sort of thing. Although you're right, in the movies, it's way more fun. And in this instance, though, because we're dealing with the city and Planned Parenthood, they're kind of more formal corporate organizations. It's pretty straightforward. The good news is, once that process is completed, that process always takes a couple of weeks since we filed our lawsuit. But once that process is completed, then you're right. Then we get to go into the other fun part, the really fun part, which is getting a hearing scheduled and starting to make our arguments.
Okay, so you got the first email. What does that mean? Like, what are we typically talking about now in terms of timing?
Yeah, so I think for starters, they have 30 days, I want to say, to file a response to the lawsuit. And then we'll have they'll either file what's called an answer or a motion to dismiss. And then we'll get some time to brief that back and forth. And then eventually we'll have a hearing. So my guess is the hearing will still probably be at least 3 months away, because we'll have to go back and forth on a set of briefs about what the law should be in advance of that hearing.
Okay, that's fair. Just interesting to get a little behind the scenes there, because
Yeah. Well, the other, kind of interesting part of this case, I think, will be whether we have an opportunity to do depositions, right? To actually sit down across the table from the various city administrators who are responsible for this program, and just ask them, what prompted you to do this program, and I think bring out that truth that this was, and it shouldn't be hard to show that this was always about the council making a political statement. But once we can get that in sworn testimony in the record, I think that'll be really powerful for a judge to show where this came from and how it was always about making a political statement and not about services or anything else.
All right. Well, wait, there's more. Believe it or not, that is not the only case we're working on together here between the Rio Grande Foundation, or myself, and the Liberty Justice Center, and yourself. We are also suing New Mexico's Secretary of State over essentially a whole suite of campaign finance rules and regulations relating to the First Amendment. So this has been going on a bit longer. I think the law passed in 2019 that we're suing over, but this has been an issue for several years. So why don't you lay that one out for us?
Yeah, well, the simple starting point, I think, is in your question, Paul. Like, it's a campaign finance law that we're challenging. Does the Rio Grande Foundation, as a 501c3 charitable educational nonprofit, do you endorse candidates for office?
No.
Do you tell people how to vote in elections?
No.
So for candidates, like, no. So like, this prompts an obvious question. Why is a campaign finance statute affect an organization that doesn't do campaigns? Right. And that's the heart of our challenge. The heart of our challenge is to say private, charitable, educational, nonprofit organizations like Rio Grande shouldn't give up their free speech rights to talk about elected officials, to talk about public policy issues, to talk about bills in the legislature, just because those elected officials are running for re-election, right? Because if we couldn't talk about elected officials when they're running for re-election, like, we could never talk about any elected officials, right? Because 95% of incumbents are always running for re-election, especially in the legislature, right? Especially when there are no term limits. And so by crafting a law that regulates speech about issues, speech about elected officials, when you're treating it like campaign finance, you're just sort of blowing past those First Amendment limits. So that's the basis for our lawsuit. As you point out, we filed it a while ago. And when the district court judge, the trial court judge, heard it the first time, she essentially said, well, the election's over. The election since you filed it is over. So I'm just going to dismiss the case because the election's over. And so we appealed that to the 10th Circuit, which is the regional court of appeals that covers New Mexico, Colorado, Utah, a couple other Mountain West states. And our argument was basically, hey, this law applies to all elections, right? This law is not specific to the 2020 election or the 2022 election. This law applies to all elections, and Rio Grande Foundation intends to keep speaking about elected officials, right? The foundation's not going anywhere. Its educational mission isn't stopping. The issues that it cares about aren't going away. And so this case isn't moot. This case needs to be heard on the merits because this law applies to all elections, not just that one particular election. So the good news is we won on that point. Just a couple weeks ago, the 10th Circuit issued a great opinion affirming the right of Rio Grande and other groups that participate in election, or that speak about issues, I should say, on an ongoing basis to bring lawsuits not specific to any individual election. So the good news is we won. The bad news is we only won on the process. We still have to win on the merits. And so now we'll be going back down to the district court to restart the process on the merits and actually get to the core First Amendment question of how this law applies to groups like Rio Grande and others that really just engage on free speech about elected officials and issues, and not about candidates and campaigns.
Now, just to be clear, of course, this is a federal court case, so whole different court setup than the other case. And we were initially, I guess, there was some issues with what's called standing, which is a bit of an arcane legal term, but that was the at least recent victory had to do with standing. Can you explain what standing means and why it's so important in cases like this? Because I know there's probably people out there who are just covering their ears and they don't want to hear about arcane legal terms. But if you're going to get involved in this kind of stuff, it's pretty important.
Yeah, it is important. And it's important because it's directly out of the U.S. Constitution. So, we love the Constitution, right? We love the concepts behind the Constitution, but those concepts are embodied in words. And the words in Article 3, which sets up the Supreme Court and the rest of the federal court system, the words in Article 3 say that the courts of the United States will have judicial power as to cases and controversies. Cases and controversies. That's the term in the Constitution. So standing is the legal term that we ask, like, what's in controversy here? What's the case here? Do you have an actual dispute with somebody? Or are you just looking for a federal judge to give you an advisory opinion? Are you looking for some free legal advice from the federal judge? Are you looking for a federal judge to decide a case or to write a law review article, right? And so the Constitution says, and this concept of standing that reflects this constitutional principle says you have to have an actual case or controversy. There's to be an actual disagreement between two people disputing what the law is or how the law applies to a situation. And so in this case, the reason we were arguing over standing is the district court judge said, hey, the election's over, so there's no dispute anymore, right? Like, you sued before an election. We didn't get the case decided before the election. The election is now passed, so the dispute is over because the election is over. And so our response to that is to say, actually, like, this was never about one election. This is about the rules for all the elections. This is about the 2020 election, the 2022 election, the 2024 election, the 2026 election. Like, this law is on the books for all elections. And so the dispute is ongoing because the law remains in place for future elections, and Rio Grande is going to keep pursuing its mission in future years. It's going to keep talking about issues and elected officials in future years. So the dispute is ongoing, and therefore we have standing. We still have a case or controversy. So that's it in simple terms. Hopefully simple enough.
Well, that's very helpful, and it seems that I'm not going to complain about the legal system and justice moving slowly, but yeah, if they want to deny us standing, it would seem like maybe they could just give us a direct decision every single time. That would be unrealistic, but if they're going to play these games on standing, it seems like then they should just answer our questions whenever we have them. See, is this legal? Is this legal? Is this legal? I know.
That's a large part of why I love my job, right? Is the cases we get to do at Liberty Justice Center. It's never like, did he pull the trigger or not, right? Like, was he the guy who did the crime? Did this corporation actually, pump pollution into the environment, whatever. It's never a fact question. Like the questions we're always asking are, the facts are obvious. The New Mexico legislature adopted this law. The Albuquerque City Council adopted this ordinance. Now just tell us what the law is, right? And for a nerd like me who loves the law, that's a great case. And so hopefully now in both the federal case we've been talking about and in the Albuquerque case, because they're really, simple, clear facts, hopefully we'll have a faster resolution, because really we're just asking a judge to say, tell us what the law is.
Now, real quickly, and I don't want to get into too much detail, but basically this area is one of the most controversial areas in current, using the fancy term, jurisprudence there. It's something that really has been litigated and Citizens United, I think most famously, but you kind of alluded to it, but the Supreme Court doesn't seem to jump on or jump at the opportunity to litigate these kinds of cases, but maybe ours could be one that goes all the way up to the U.S. Supreme Court. What's the kind of state of play, broadly speaking?
Yeah, great question. So you're right. We really haven't had a major campaign finance case since Citizens United, which was over a decade ago. And one of the things that has changed in a major way in the subsequent decade, actually two things have changed in a major way in the subsequent decade. One is cancel culture, right? I don't think when Citizens United was decided, we had any inkling of the cancel culture that we live in today. The other is the membership of the court. That 10 years ago, 12 years ago, when Citizens United was decided, we didn't have Justice Gorsuch, we didn't have Justice Kavanaugh, and we didn't have Justice Amy Coney Barrett, and we didn't have Justice Jackson for that matter. And so 4 of the 9 justices are new to the court since Citizens United. And so I'm hopeful that we're going to get another major decision here in the next few years, where we see, do Justices Kavanaugh or Barrett, do they share the same views that, for instance, Justice Kennedy had about disclosure, or has the reality of cancel culture sort of shifted how the justices see the law? And as a result, are we going to get a more free speech protective and privacy protective constitutional doctrine? That's my hope. That's what we're arguing for in New Mexico. It's what we're fighting for in Alaska and several other states against what I think is this expansion of campaign finance to cover everyday people doing everyday stuff that's not actually campaigns, because the left just wants to know and bully everyday Americans who disagree with them. And we're going to look to the courts and eventually the Supreme Court to draw a strong line that protects the privacy of everyday Americans to participate in the public square without giving up their free speech rights.
Yeah, it's frustrating in some ways. The court, we'd like to see them take bold stands. I mean, they have this reputation as, conservatives, et cetera, but in reality, they tend to be very reticent or have been to take up cases in this particular area of law. So, you never know what cases they'll wind up taking and how that would impact future rules and litigation on this subject. But it seems like sometimes you get into chaos at the state level with all kinds of different, different districts ruling in different directions and different laws being enacted. It's kind of interesting. I know people complain about the Supreme Court, what they call it, not ruling from the bench, but making laws from the bench. But it would also clear things up a lot, I guess.
Yeah, that's right, Paul. So we have seen such substantial progress for for religious liberty, for instance. This court has been huge in taking bold steps on religious liberty. We've seen major decisions on like the Second Amendment, the Bruin case last year, big cases like Janus, right, where the court has been willing to be bold in enforcing constitutional principles. And we have yet to see that in campaign finance in the last decade. And our hope is, and we're going to keep bringing these cases, because frankly, it's not that we're trying to, bring a case to the court. It's that the left, it's that blue states are enacting continually more and more aggressive regulations of free speech. And so we need the court to step in and draw that clear line, like you said, end some of the confusion and just draw a clear line that says to these blue states, like, you can't go beyond this point. You still have to respect people's privacy. You still have to allow people's free speech, even when you don't like what they're doing. And that's the goal. That's the kind of case that we're waiting for the court to have.
All right. Well, thank you very much for your time and all the information. And any idea the timeline of when this case will move on to the next step and what that step? So you said that the appeals court said it could move forward. Does that mean that the full appeals court, because there's en banc, and I'm sorry that this is again outside my purview, but this just means it gets a full hearing at the appeals court, correct?
Actually means it'll get a full hearing now back at the district court.
Oh, okay.
That essentially they're going to send it back to the district court, say, you got it wrong. We're going to reverse what you did the first time around when you dismissed it for lack of standing. So now hear it again and decide it on the merits. Like, they've got standing. So now you have to actually decide the First Amendment question.
Got it. All right. Well, anything else you want to share before we have to let you go?
Hey, I'm so glad to be here. If you want to learn more about what we're doing at Liberty Justice Center, if you want to learn, follow what's happening in these cases, the Horseman's case, the union cases we're doing, the easiest way is on Twitter at LJ Center. You can follow me. I'm at Daniel Suhr, S-U-H-R. And you can always visit our website, libertyjusticecenter.org, learn more about what we're doing, and join us in the fight. And if you know a liberal who needs suing, send me an email. We always are looking for cases and clients. So thanks so much for already being a client, Paul, and thanks for having me on the show.
All right. Thank you, Daniel. And, you never know, we might have another liberal to sue here soon. We just, we're always out there looking as well, but
the joys of living in a blue state. It's full
exactly
for people like me.
Yep. Thanks for listening to this week's episode. Find all episodes at tippingpointnm.com or at the Rio Grande Foundation's YouTube channel. Subscribe to the show at Apple, Stitcher, or have your Google Home play Tipping Point, New Mexico. Thanks to Path 3 Marketing for producing this show.